Hi, my name is Dustin Taylor, and I'm a partner with the law firm of Husch Blackwell. Today, I'm going to be providing a data privacy litigation update regarding the Video Privacy Protection Act. Husch Blackwell is an AmLaw 100 firm with over 800 attorneys and more than 20 offices. Our Denver office, where I currently sit, is located at 1801 Wawata Street in Denver, Colorado, 80202. As part of the Denver office in Husch Blackwell, I sit in our Technology, Manufacturing, and Transportation Strategic Business Unit, and my practice focuses on litigation, including patent, trademark, trade secret, and data privacy litigation. I'm going to be talking more and specifically about data privacy litigation today. In any conversation regarding data privacy litigation needs to start with where are we now? As of now, there is no federal privacy law yet. Instead, many states have passed or will soon pass privacy laws of their own. And on the screen, we see a map that is at least updated as of June 20th of this year, showing which states have enacted legislation, which have active legislation, which did not pass in 23, which have excluded, and which simply haven't even proposed a bill yet. This is changing rapidly, and I encourage you all to follow our blog on Byte Back, BYTE, back, to continue watching and learning how states are passed and how states are addressing these privacy laws. Now, with the exception of one, which we'll talk about at the end of today's presentation, these states have not, any of the privacy laws do not include a private right of action that allows a plaintiff to bring a civil suit for a violation of one of these laws. Instead, we see privacy plaintiffs adopt what I call the square peg round hole approach. Because there is no private right of action for a violation of privacy, we see privacy plaintiffs allege that what is commonly considered to be a privacy right violation violates some other law. For example, privacy plaintiffs have alleged that use of chat communications on websites or session replay technology on websites violates wiretapping laws. They've alleged that simple use of ad tracking software that transmits URLs when the URLs contain consumer input search terms also violates wiretapping laws. We've seen claims of invasion of privacy, invasion of constitutional right to privacy, false advertising, voice recording, and intrusion upon seclusion. We've also seen allegations that certain conduct violates the VPPA, or Video Privacy Protection Act, which we're going to talk about more today. What is the VPPA? The VPPA states a videotape service provider who knowingly discloses to any person personally identifiable information concerning any consumer of such provider shall be liable to the aggrieved person for the relief provided in subsection D. This is from 18 U.S.C. section 2710. Now, there are a couple important things to unpack here. First, as you can tell from the citation, this is a federal legislation, which means that we're not limited to claims in a specific state, and we're seeing claims across the nation. Second, the photo here, if anyone would recognize this person without prompting, this was Supreme Court nominee Judge Bork, who in the late 1980s was nominated for a role on the Supreme Court. During his nomination hearing, however, somebody released his videotape rental history. And when I say videotape rental history, I do actually mean where he'd gone to a store, rented videotapes, and there was a log of which tapes he had rented. I believe it was a newspaper had obtained a list of that and published it. I don't know if it was in the hopes of embarrassing him for having rented the Goonies too many times or for some other purpose. But in the late 80s, this caused quite the scandal. And Congress, doing sometimes what Congress does best, overreacted and passed the VPPA, which is still in effect today. For a while, however, and starting in 1990 onward, we didn't really see many cases or many decisions that cited the VPPA. It was recognized for what it was, a fairly limited role that was passed in response to a very specific situation. In 2012, however, we see the number of decisions citing the VPPA skyrocket from about 3 to 17. And post 2012, we've seen a lot of these high numbers again. And this graph is from earlier this year and is taken from, again, one of our Bite Back Law blog posts. And I've got the link for the source here if you want to read more on that. The VPPA has some key statutory provisions that really matter to any analysis of potential exposure and liability to a VPPA claim. Subsection A says any person aggrieved by any act of a person in violation of the section may bring a civil action in a United States District Court. So fortunately, we're not really concerned about facing any sort of these claims in state court, because the civil claim provision provides that the action can only be brought in a United States District Court. Next, it claims that the VPPA provides that the court may award actual damages, but also does provide liquidated damages in the amount of $2,500. What that means is that we will often see claims of VPPA litigation accompanied by a class action claim. The VPPA also provides that the plaintiff can recover punitive damages and reasonable attorney's fees or other litigation costs, and can also provide equitable relief. The third key statutory provision for the VPPA is that no action can be brought unless the action began within 2 years from the date of the act complained of. So we do have a statute of limitations for the VPPA, but it is fairly large with 2 years for what we consider how quickly this technology moves. There are a couple of key terms that the VPPA defines that we're going to walk through. First, videotape service provider. The VPPA says this is any person engaged in the business in or affecting interstate or foreign commerce of rental, sale, or delivery of pre-recorded video cassette tapes or similar audio visual materials. Where we've seen this matter is that websites that deliver videos across the web have been alleged to be engaged in the delivery of similar audiovisual materials. The other key component, which we'll talk about in a little bit more detail in a few moments, is that it applies to pre-recorded video or similar audiovisual materials. Next, the VPPA defines consumer as any renter, purchaser, or subscriber of goods or services from the videotape service provider. We'll talk about why that matters in a little bit more detail. Finally, the VPPA defines personally identifiable information, and it includes information that identifies a person as having requested or obtained specific video materials or services from a videotape service provider. What issues do we commonly see in VPPA claims? And we'll walk through each of these in more detail. But at a high level, it matters whether the defendant is a videotape service provider. Obviously, if they weren't, then they're not going to have liability under the Act. If the video content at issue is pre-recorded, as we just saw, that is actually a requirement for the definition that we just looked at. Whether the defendant disclosed personally identifiable information, again, a key statutory definition. Whether the defendant, if they did disclose personally identifiable information, whether they did so knowingly, whether the plaintiff is a subscriber or can otherwise meet the definition of a consumer, and finally, whether the defendant obtained consent to share the plaintiff's information. I'm going to kind of preview the answer on this one. If you are at all facing a VPPA claim in modern trends, you likely have not obtained consent, because the VPPA provides very strict and stringent requirements that we'll talk about in a little bit more detail. The first issue we're going to take a deeper look at is whether the defendant is a videotape service provider. And as an example, we're going to look at the Gannett case from December 2022. There, the plaintiff argued that the defendant was a videotape service provider as defined by the VPPA because they were engaged in the business of delivering computers containing video content, which are, as we discussed earlier, similar audiovisual materials. The plaintiff stressed that the VPPA was not limited to entities primarily engaged in the business of providing audiovisual materials or limited to some sort of content, medium, or duration of audiovisual materials. And here the court agreed with the plaintiff and rejected the defendant's arguments to dismiss that claim. Here in the WebMD case from the Northern District of Georgia, where we've actually seen a good number of VPPA claims brought, this decision is from November 2022. Again, looking at whether the defendant, this time WebMD, was a videotape service provider, the court again agreed with the plaintiff and found that the plaintiff had plausibly pled that the e-newsletter service constitutes a good or service under the VPPA, that it provides subscribers with doctor-approved health tips, and that WebMD, the defendant, monetized those newsletters by selling advertising space along to generate revenue. The court found that such allegations were sufficient to state a claim that the e-newsletter was a good or service, and the court looked at the broad interpretation of goods or services to encompass all parts of the economic output of society. So in most instances, we have seen the plaintiffs be considered to be a videotape service provider where the website provides some sort of video content that is streamed or otherwise provided to the defendant. The next issue that we see is whether the video content at issue is pre-recorded. And again, this is a statutory requirement, as are most of these issues. And in the LUF, the NFL Enterprises decision, the court found that the video content was not pre-recorded because it was streamed. So if we're looking at something that is, for example, uploaded to YouTube and shared from YouTube, more likely that it's going to be pre-recorded and potentially fall under a VPPA claim. In contrast, if we're looking at something that is streamed, for example, something like a live stream on Instagram or Facebook or some other sort of live content, it's more likely that we're not going to have some sort of, or again, live television, kind of as with the NFL case here, we're going to have less risk of the VPPA claim. The next issue we're going to consider is whether the defendant disclosed personally identifiable information as that term is construed. Now, what is personally identifiable information? Courts are honestly all over the place on this. Maybe some things that may not be considered to be personally identifiable information, or PII, a device ID, an IP address, the user's browser or operating system settings. What has been found to be PII, the Facebook ID is probably the most proliferant example of what has been PII, because courts have found that taking the Facebook ID and pasting or pasting it in can pull up the specific profile of an individual person and can identify that person. Another court had found that GPS coordinates can identify a very specific person because it identifies exactly where that person is. And I did say that maybe not PII, and we're going to take a look at that here in a few minutes. And by a few minutes, I mean now. In the Etchenberger v. ESPN case from the Ninth Circuit, so we are dealing with an appellate decision here in 2017, the court applied the definition of PII under the VPPA and found that the complaint was deficient. The plaintiff had alleged that the defendant, ESPN, had disclosed to Adobe the plaintiff's Roku device serial number in conjunction with the names of the videos that the plaintiff had watched. But the court says that's not enough to identify the individual unless it is combined with some other information in Adobe's possession that ESPN is not disclosing. They never disclosed that, and they never even possessed it. and the court says that is not personally identifiable information and that there was no liability. Now, here we're going to be looking at the Meredith Court case from the Southern District of New York in February of earlier this year, which again was considering whether the defendant disclosed PII. Here, the court again dismissed. There's another instance where the court dismissed the complaint because they had not requested, had not disclosed PII, showing that the person requested or obtained specific video materials. Here we are looking at the use of the Facebook pixel, but the point of this slide is how that pixel is conveyed really matters. So even though by itself it was personally identifying, it wasn't in conjunction with information to disclose that the person requested or obtained specific video materials or services, because the pixel had been configured to only show the URL that the website that the person had visited and not the names of any of the specific videos. The court walked through a couple of examples and noted that the name of the video was very specific, whereas the name of the web page was more general, and that the pixel was being used to transmit only the name of the URL. In some instances, the website or the web page contained more than one video, and simply passing on that the user had access to that web page didn't show whether the user watched one, both, or none of the videos, and that all of those were possible. So simply passing on the URL of the page itself without passing on any information regarding whether a video was clicked or otherwise accessed, this court found that was insufficient for liability under the VPPA and dismissed the complaint. In contrast, a lot of courts have found certain things do constitute personally identifiable information. In the Gannett case, which we touched on earlier, the court found that the Facebook ID was PII. Gannett satellite info case, the court found the disclosure of GPS coordinates constituted disclosure of PII and denied the motion to dismiss. And the Enri Vizio case, this is actually why the earlier slide that said that some device hardware information was not or maybe not PII, because the Enri Vizio case denied a motion to dismiss where the disclosure included consumers' IP addresses, zip codes, product model numbers, hardware and software versions, chipset IDs, and region and language settings, which together amounted to the disclosure of the PII. Now, in this case, the court really leaned in to some disclosures and statements from the defendant, which had touted its ability to identify people using this type of information. So looking at this, the court had said, okay, well, you have already said that this information can be used to identify this person or identify a person. And the court relied heavily on that in finding that this was PII. Most other courts have found more kind of hardware descriptive device information like this is not PII. If the defendant did disclose PII, the next question is whether they did so knowingly. Here we have the Enri Hulu privacy litigation case from the Northern District of California. This is a comparably older decision in 2015, and the court found that the defendant did not, the defendant specifically Hulu here, did not disclose any information knowingly, because when it disclosed information to Facebook, it had no idea that Facebook could combine the user's identity, which is the Facebook ID contained in the C_user cookie, with the watch page address to yield personally identifiable information. So here the court was focused on whether Hulu or the defendant knew that how the information would be used. Subsequent cases, however, have rejected this theory and really focused on whether the defendant took the disclosure action itself knowingly, regardless of whether they knew how that information would be used. And we see in the WebMD decision, and I've highlighted, or excuse me, I've bolded the key language here, where the court finds that the plaintiff plausibly alleged the defendant, Webb, indeed consciously transmitted the consumer's private information. Here's another decision that is on the same effect. The court was looking at whether Star Tributary Media Co., this is March 7, 2023 decision, again, whether they had taken the disclosure action itself knowingly. And here the court found that they did. The plaintiff plausibly alleged that the PII was consciously disclosed, and the court said that's enough. It doesn't necessarily matter that you know how the defendant is going to use it or what it's capable of. It's knowing is met if the action itself is taken knowingly. The next issue that we look at is whether the plaintiff is considered a subscriber or otherwise meets the definition of a consumer and is therefore entitled to bring the claim. In the Scripps Network case from the Southern District of New York in April earlier this year, the court really hammered in on the relationship and whether the relationship was related to the video services that the defendant allegedly provided. The complaint in that case had described the plaintiff as a subscriber trying to meet that definition of HGTV.com's newsletters. But the court says it did not plausibly allege that they were subscribers of any video services, which are not alleged to entail any commitment from viewers. The complaint did not include any facts that alleged the status as newsletter subscribers was a condition to accessing the site's videos or really enhanced or otherwise benefited any viewing experience. So we see the court really hammering in on, okay, you may be a subscriber or you may be a purchaser, but what does that have to do with the video type services that you contend are provided? The next issue we see is whether the defendant obtained consent, and I previewed this earlier, but this is the statutory requirement of consent, and as I said, it is a fairly high standard. The consent has to be in writing, although electronic means are allowed. The consent has to be distinct and separate from any form setting forth any legal or other financial obligations of the consumer. What that means is if we're going to see a disclosure of VPPA and trying to obtain consent and as part of a broader privacy policy or terms of use, that's not going to meet the distinct and separate requirement. We do actually have to have some sort of independent consent on the for disclosure of video content under the VPPA. And here we take a look at an example of this where the District of Minnesota in March of this year rejected an argument that the defendant had obtained consent. And the court says, recall that the VPA says consent must be in a form distinct and separate from any other form setting forth legal or financial obligations. And the court rejected the defendant's argument that they had obtained consent. In summary, the VPPA is merely one of many claims and theories that we are seeing privacy plaintiffs bring these types of allegations. It is probably one of the larger ones currently, but as we'll kind of see on the next slide, we are watching some additional ones. We're also seeing VPPA claims and wiretapping claims, both brought in conjunction with other types of claims, most commonly intrusion upon seclusion, invasion of privacy, constitutional right to privacy. So any motion to dismiss is having to include and fight not just one claim, especially in the context of wiretapping, but having to fight many different claims, which can simply drive up the cost of defending any sort of those litigations higher. In addition to what we're currently seeing plaintiffs bring, we're also watching a couple of other data privacy litigation trends. And for more information on this, you can subscribe to our Bite Back blog post where we do monthly data privacy litigation updates, which looks for trends in these types of things. But the key point I want to make on this slide and if you do follow the blog, you'll see this section under, you'll see this material under the section of on the horizon. For purposes of today's presentation, I've instead described it as what's next, which is a key phrase of one of my favorite television shows, The West Wing, with President Bartlett shown on the screen here, as very commonly known to focus on the next thing and ask what's next. And that's something that we're doing as well. And what are we watching? Having a handle on claims like the VPPA or claims like the wiretapping claims, what's on the horizon, what's next. And at a high level here, we are seeing Washington State was actually the first state to pass a private cause of action under its privacy law, which is the My Health, My Data Act. That goes into effect soon, and we're watching for what claims can be brought under that. We're also seeing more scrutiny on ad tracking pixels themselves. We're watching claims that use of voice recording security software can violate California Penal Code Section 637.3, which prohibits the use of pre-recorded voice recordings to determine the truth or falsity of a statement. We're watching claims that, yes, you have a cookie banner, but what happens if that cookie banner is malfunctioning? What claims does that bring, and how does that expose you to additional liability? We're watching claims that simply creating a data image and a data profile of someone based on the data that you collect is a misappropriation of that person's name, image, or likeness. And the final one that we have here are simply unknown. The takeaway from this slide, the key point, is that this is a rapidly evolving landscape and it's always changing. If you'd asked somebody 5 years ago whether, maybe 10 years ago, whether somebody would be liable for the VPPA violation for sharing an ad tracking pixel on a video that somebody had watched, chances are that the answer would be no. And even in the early 2012 cases, we were typically seeing these types of claims be limited to actual videotape rental history. Somebody purchased a videotape or purchased a DVD, and the ad tracking had shown that somebody had actually purchased this information and was sharing purchase history. And only the past couple of years, really the past 12 to 18 months, have we seen the explosion in cases that allege Video Privacy Protection Act, VPPA claims from simple video hosting in conjunction with ad tracking software such as the Facebook Pixel. So the takeaway from this slide is this is rapidly changing. It's vital that you keep up, continue attending webinars such as this one, continue following the blog, and just kind of keeping abreast, because you always want to be ahead of one of these claims, never learning about something when you receive a demand letter for the first time. With that, I thank you all for attending and wish you a great day.